Welcome. Today I'll be going over the drudgery of the civil court process. Have I gone overboard in my explanation? Yes, but that makes it more fun for me, and before we begin, I would like to issue a fair warning that if you hear any shifting in the background, that would be my cat, and not some rat overtaking my home, even though she is acting like a rat currently. Before a civil case can go to trial, we need a triggering event or the wrongdoing that a potential plaintiff experienced. This can be damage either to themselves or their property, and they believe that they deserve a reward for what they experienced. Our triggering event today will be a YouTube prank video gone wrong and unfolds from there. Hey guys, it's Justin. Welcome back to my channel. Today we're going to be pulling a prank on a stranger to make them believe that I have a real gun. Don't worry guys, it's fake. And I think that I've just found our target. Let's get her. Shh. Hey, you. We got her. You shot me! Yet another successful prank. Tune in next week to see me commit Grand Theft Auto. From there, our plaintiff can decide that the triggering event was worth a lawsuit. Before any suits can be filed, a lawyer needs to be hired first in an informal discovery period. This is a period where the court has no knowledge of the potential suit. The plaintiff can meet with various lawyers and discuss the basics of the case to determine if the individual's best fit to represent them through an exploratory conversation. Once the plaintiff chooses an attorney, they meet to discuss the course of action in carrying out the case. From there, the plaintiff and the attorney discuss how payment will be collected. They can agree to a contingent fee where the attorney receives a portion of the winning, charges by the hour, charges a flat rate, or as a retainer. After payment is discussed, the plaintiffs and attorney's lawyers have a settlement conference without their clients to try to settle out of court. Proceedings continue if no settlement is reached. The plaintiff makes a written complaint and then the defendant answers. Both parties have the ability to tell their version of the story to the court, and the plaintiff can sometimes make a reply to the defendant's answers. In the complaint, the plaintiff alleges jurisdiction, establishes facts that ensure the claim is legally standing, and demands relief from the defendant. In the answer, the defendant either admits or denies the content of the complaint. They can also claim that the complaint isn't legal or make a counterclaim against the plaintiff. The defendant can make affirmative defenses that are in response to the plaintiff's facts, claiming that the plaintiff should not win because what they are saying is not true. This is their time to refute the facts. If the defendant has a cause of action, then they can make a counterclaim and that the plaintiff's claim of damages actually happened to the defendant. In the reply, the plaintiff can either admit or deny the counterclaim. The defendant receives a writ of summons or the process that tells them that they are called to the case. This is served by a process server or the sheriff in cases of personal service. Substituted service involves mailing a summons or leaving it with a suitable person who lives in the same house. More common in the past was putting a summons in a law section of the newspaper called constructive service. Since newspapers are going out of style, it's not very common anymore. Maybe we should post it on Twitter instead. If the defendant ignores the summons and fails to write a written answer within a certain time period, they default, and the plaintiff is automatically rewarded. If a complaint is poorly assembled, lacks sufficient evidence, does not summon the correct person, or is presented to a court that does not have jurisdiction, attorneys can make a motion to dismiss, sometimes referred to as a demurrer. Right. This is usually carried out by the defendant's side, and the judge makes the final decision. If the judge dismisses the case, then the plaintiff can fix the problem and reapply the complaint. Your Honor, my client was simply being a silly, goofy guy. Are you really going to put someone such as Justin Kerprank on trial? Motion denied. A summary judgment can be proposed by either party, intended for use when there seems to be a lack of evidence. If the facts do not align and it is impossible for the defendant to have committed the action they are accused of, then the case can be dismissed. During the discovery process, both parties have the right to obtain information retained by the opposite party. They obtain factual information that encompasses the total area of the controversy. The information used to support the claims must be relevant to the trial, but the attorneys can gain access to files, emails, and expert witnesses. Yeah, man, there's this chick from Tinder who works at the mall. Next video, I'll shoot her. Great. One aspect of the discovery process is called the oral disposition. This happens when a witness to the crime is interrogated under oath and deposition outside of court. Both parties must be aware of the deposition, and both attorneys must be present for cross-examining.
Where were you on the afternoon of February 27th? I was at home, editing Justin's video from the week before. Were you really? Yeah, I was at the park and I watched that lady get in.
Written questions are also held, consisting of written questions given to both parties. Attorneys may also ask for the production of documents or other things in the possession of the opposite party. If the mental or physical condition of the plaintiff or defendant is called into question, the opposite party may order a mental or physical examination.
Do you really think you're mentally capable of understanding the intricacies of this case?
Why wouldn't I be? I got a torn retina, not a concussion.
About that.
Parties may also request admission or denials to certain facts, and not the complaint as a whole. Before a trial can begin, the jury first must be selected. After being selected at random from the community, potential jurors are brought into the court where an voir or an oral examination is conducted by both attorneys. While considering the criteria for selection, there are a couple of reasons why jurors may be dismissed. A challenge for cause can eliminate a prospective juror based on their displayed bias, prejudice, affiliations, relationships, and so forth.
And why do you think that you're fit to serve on this jury? I am a Justin Kerprank super fan. I've been subscribed to his channel from the beginning and I paid $2,000 for an autograph. You're dismissed. I'm sorry, you said that... I said the technology is evil and anyone who puts their likeness on the internet is marked by the beast. You can go.
A perempting challenge allows either attorney to dismiss a potential juror for any reason other than their race.
I just get bad vibes. Bad vibes. Yeah, bad.
But only a limited number of perempting challenges are allowed, so be careful. First, the plaintiff's attorney begins the trial with their opening statement. For a civil trial, it's not very long. You don't want to put your jury to sleep before it gets juicy. The opening statement gets over the basics of the case, legal theories, and the way their evidence will prove the facts of their case. The defendant's attorney has the right to choose either to present their opening statement right after the plaintiff's attorney, or they can wait until the plaintiff's side is done with examination to present. But obviously they mostly present right after the plaintiff's side because they want that information to be back to back. Speaking of examinations, the plaintiff wins their case by proving their allegation and presenting evidence to back those claims. Both sides of the case present witnesses and evidence to support their allegations. In the direct examination, witnesses are asked questions by their own attorneys. They very rarely ask their clients leading questions and only ask them to present their stories.
Please go over the events with me. Well, I was at the park and suddenly somebody yelled at me and he had a gun. I thought that it was real, and the next thing that I knew, I was on the ground and my hand was covered in my own blood. And can you identify the man who injured you in this courtroom? Yes, I can. He's right there. Mr. Kerprank, you said that this has had an emotional toll on you? Yes, I've lost 1.8 million subscribers on YouTube since she posted that inflammatory video on TikTok. I don't know how I'll ever recover. Miss Fowler, have you had any contact with Mr. Kerprank before? Yes. We matched on Tinder, but I stopped responding to his continuous messages when he told me that he ran a viral YouTube channel. His video about setting a nursing home on fire made me extremely uncomfortable. How did the afternoon of February 27th proceed? I went to the park to shoot a video. Alone. And then I chose Miss Fowler as my target. The bullet didn't even make contact with her. I bet she stabbed herself in the eye with that bullet.
Witnesses can be voluntary, but they can also be subpoenaed if they refuse to attend the trial.
I'm sorry that you were less willing to attend our little trial. Can you tell me about what you witnessed on the afternoon of February 27th? I witnessed Justin Kerprank ruthlessly shoot a citizen in the eye.
Then, witnesses can also be subpoenaed ducis tecum, which requires them to bring certain documents or evidence in their possession.
And what have you brought in for us today?
70 pages of text messages from Justin about how he not only shot the plaintiff, but committed other crimes.
From there, the opposing attorneys conduct a cross-examination against their witnesses. In a cross-examination, attorney asks their opponent's client leading questions that may suggest they already know the answer. Attorneys never ask questions they don't already know the answers to.
And after seeing Mr. Kerprank, you decided to frame him for your pre-existing eye injury. Isn't that right, Miss Fowler? No. Miss Fowler, you publicized a video on the internet, isn't that correct?
Yes, ma'am.
And in this video, you suggested that Mr. Kerprank's fans boycott his channel, right?
No, not really. I was simply making the internet aware of the situation and suggesting that his fans take his past violent behavior into consideration.
Please see Exhibit C. Mr. Kerprank, you've never posted a video of one of your pranks causing harm to a victim, isn't that right?
No, ma'am.
Right. I'd like to reference Exhibit 10. Ready? I'm going to read some excerpts from your videos. I caused a 15-car pileup by putting a baby mannequin in the middle of the road. I brought all the dogs into the shelter and released them into an elementary school. I put my grandpa into a flooded basement. Shall I continue, Mr. Kerprank?
No. Following the cross-examination, attorneys can conduct a redirect examination of their clients. They can also call upon expert witnesses to testify, who are the only ones allowed in the trial to speculate.
Please do clarify, could the injury to Miss Fowler's eye have been self-inflicted?
Potentially, but not in this situation. She couldn't have injured herself with a bullet like Mr. Kerprank suggests. It's more than likely that the velocity of the bullet would have caused substantial damage, especially at the distance from which she was shot. Judges are in charge of their courtroom maintenance and ensuring the rules established by the state regarding evidence are upheld. Firstly, evidence must be relevant. Relevant evidence must logically contribute to the case, otherwise potentially confusing the jury. Evidence must also be material and probative, meaning that it is important to the case.
Before this, Miss Fowler, you only had 2 subscribers on YouTube, isn't that right?
Objection, relevancy. She's not since posted on YouTube.
Sustained.
Evidence must also be competent, meaning that it is legally adequate. This applies to witnesses as well, who are under oath to tell the truth while on the stand. They cannot speculate about events and can only testify what they experienced and know to be the truth. When a witness presents evidence that they did not experience firsthand and instead heard from someone else, either written or said, it's called hearsay. You can't always trust what others have to say.
Then, Freddie said that Macy said that Miss Fowler said that we were hearsay.
Included under hearsay is spontaneous declaration rule, meaning that something someone said right after the crime occurred cannot be admissible as evidence since natural reactions are not always truthful. The best evidence rule states that, unless unobtainable, evidence must be presented physically on the trial and original documents should be used instead of copies. There's also a rule that states that certain communications are privileged, or privileged communications. Certain people are exempt from testifying against those they share a relationship with. You can claim the Fifth Amendment and refuse to self-incriminate. There are certain privileges between spouses, and there's doctor-patient and attorney-patient confidentiality.
I call Faye Archer to the stand. Sustained.
If the defendant's attorney believes that the plaintiff's team did not present sufficient evidence, then they can call a motion to dismiss. The judge makes this decision only if they think that the plaintiff's team didn't sustain their allegations against the defendant. In this scenario, the case is thrown out and has to start from the beginning.
I make a motion to dismiss. How can we be sure that that's her eye?
If the case doesn't get dismissed, the defendant then presents their case. Before the jury can make their decision, either party can make a directed verdict, claiming that a reasonable person could not disagree with the results of the case. If the judge agrees with the claim, then the jury does not have to have a say in the result. When this doesn't happen, the jury gets to deliberate on the results. Juries, though they make the important decision in the end, face certain rules. The judge gives those rules to the jury, like that they cannot visit the scene of the accident or use evidence not presented on the stand. If a party is not satisfied with the new answer, then they can make a motion for judgment notwithstanding. This is granted when the judge agrees that a reasonable person could not have reached the decided verdict. Either party could also make a motion for a new trial, and a judge may agree if they think that the awarded damages were grossly inadequate, either more or less, if there is more evidence previously not presented, or if the jury's verdict was questionable. A motion for a relief from judgment is similar to the prior. An additor is rewarded when the judgment was grossly insufficient. The plaintiff can ask a jury for additional reward from the defendant. A remitter is the opposite of an additor, occurring when a defendant believes that the plaintiff received a grossly high reward. Following the termination of the trial, a judgment is rewarded. This determines the reward at the end of the trial and the rights of both parties. The winner, in our case the plaintiff, is called the judgment creditor. The judgment debtor is ordered to pay the creditor whatever sum of money was decided by the judge and jury. If the debtor cannot pay the sum of money ordered, a writ of execution is obtained and given to the sheriff, who is ordered to collect property from the debtor. Money can also be taken from the debtor's paycheck if it comes to that. Thankfully, our new friend Justin Kaprank can pay his debt in full because his ordered payment was just the revenue from his fake gun video. That was a lot. It's over now and our plaintiff thankfully won. Maybe she should bring up a criminal case next about her stalker, but I don't think I'm ready to dissect that.